to, but that's okay. So, getting ready, I guess, for this whole series of sort of end of life preparations. And obviously a will plays into that, and I will talk about wills in a bit, but almost the more important documents in many families are these two handouts I've given you. One is a Georgia Advanced Directive for Healthcare, and the other is a statutory power of attorney. So I'll first talk about, let me first say both of these forms are statutory forms, which means that there's a statute in the Georgia Code that sets forth these forms. In both cases, the statute says that they're not the only form that can be used, but most people prefer to use them because they are set forth. So one of the most important ones is the Georgia Advanced Directive for Healthcare. This is a document. A lot of people say, oh, that's a living will. It's actually broader than that. It's kind of it's a document that lets you name somebody to make medical decisions for you if you can't make them on your own anymore. So it lets you name in advance who would be making those decisions. If you look at the first page, it just kind of tells you that this is made up of 4 parts and what those parts are. The second page is where you would actually designate your agents. So you can have a primary agent, and then you can have backup agents. You can have co-agents. So sometimes people want, 2 or 3 children acting together to make decisions. Probably most common, the spouse is the primary agent unless there is no spouse or a reason that the spouse can't serve, maybe incompetency or, and then sometimes it's a friend, a family member, a sibling who's a doctor, something like that, someone you think would be really good at making decisions for you. So the next page, page 3, sets forth all the powers that your agent has. And in a nutshell, I say, basically any decision you could make about your own healthcare or well-being, your agent is going to be able to make on your behalf. So that would be admitting you to a facility, discharging you from a facility, authorizing a treatment, surgery, any kind of procedures, and then including withholding life support. And on the next page, page 4, there are some options that you can initial, things that you may or may not want. The first one at the top says your healthcare agent has the authority to authorize an autopsy. Some people feel very strongly they do not want an autopsy, and so in that case, you could initial there saying, I don't want an autopsy. And if you read the fine print, if one's required by law, they're going to do it anyway. So if you die in suspicious circumstances, they're going to do it whether you want it or not. The next part addresses organ donation and donation of your body. Your healthcare agent has the authority to donate your body to a medical study program. A lot of people do not want that, feel very strongly. So in that case, you could initial that first line that they could not do that. Getting back to that, I think I have had some clients who do want to do that, and they have, once you feel strongly that they do want to donate their body to a medical study program, often enter into an agreement with like Emory or the University of Georgia. You can enter into agreements in advance with facilities to donate your body if you'd like. So,
Linda, is there an age limit on
I don't.
donation?
I'm not sure that there's an age limit for that. I do know there's a weight issue because I did have a client once who wanted to donate her body and she was too thin. She just, with old age and as the cause of death, she wasn't eating, what have you, and so she was too thin and they would not accept her body. Now, why that is, I don't know, but I don't think I'll ever have that problem. So. The next one, it was organ donation. So you can, if you don't want your organs to be donated, you would initial there. Your agent, the person you've designated back at I think page 2, has the authority to make the decisions about the final disposition of your body, your funeral arrangements. That can be really important because a lot of times, the family doesn't agree when somebody dies. Are we going to cremate? Are we going to have this big service? Are we going to have a little service? And under Georgia law, your agent has the authority to make that decision. So a lot of times, funeral homes will call me and say, hey, can we get a copy of that document that you prepared for them? If you want someone besides your agent to make those decisions, you could initial and insert that information there. And then at the very bottom, if you have a preference of being buried or cremated and you know that in advance, you can initial your preference in terms of that. Now, the next 2 pages are probably what most people get concerned about in this document. And that's going to talk about life support preferences. So I don't, again, this is a statutory form. I didn't create this form, so don't blame me. And that it's like full of double negatives and also doesn't go in the right order, in my opinion. But so you're gonna, in number 6, you would pick the conditions under which you would want your choice in number 7 to apply. So basically under 7 there, treatment preferences, you would say what you would want in terms of life support. And then going back to 6, you would say if that would apply in the first instance, if you have a terminal condition, and the second instance, if you're in a state of permanent unconsciousness, and those are both sort of defined there. And then the treatment preferences are A at the bottom of that page would be, that's saying you want to be on life support forever. You don't, if you're getting better, not getting better, you don't care, you want to be on life support. And I do have a few people that select that one because, you know, they usually say they knew somebody who was in a coma for 10 years or something, you know? So, yes.
One thing that should be noted in that question of life support, at a certain stage, well, you're signing that, when you sign that, if the person happens to get sick from something very, and it may not be critical, but the person may not also be given medication because it's felt that it would cause the person to live longer.
Well, I think that's probably a hospice decision.
Yeah.
And so that would
Yes,
be,
that is
yeah.
a hospice decision.
So your agent does have the authority to make those, like, to whether to, if you get to the point, if you sign one of these and you can't make the decision on your own, if you can make the decision on your own, you're going to make that decision. But if you're unable or incapable of expressing that decision, then your agent comes into place. And actually, let me back up since you brought that up. The part in italics at the top of page 5 says that your healthcare agent has overriding authority. So if you've named an agent, then they would make these decisions, but your selections are supposed to be guidance for them. If you didn't name an agent, because some people, you could just do this in theory just to fill out this part, and you don't have an agent, you're just telling your doctor what you want in terms of life support. And then that would be what your doctor would go by. So back to that. So under the treatment preferences, again, we have A at the bottom of that page. You select A, B, or C. A is you want to be on life support regardless. B at the top of the next page is allow my natural death to occur. I don't want any medications, machines, or other medical procedures that in reasonable medical judgment could keep me alive but cannot cure me. I do not want to receive nutrition or fluids by tube or other medical means except as needed to provide pain medication. So that is, you know, if it's a temporary situation, you need to be on a ventilator, you need a feeding tube to get past this, you know, incident, then you want to be on it because that's to cure you. But if it's just at the point that it's only keeping you alive and it's not for curative purposes, then you don't want it. And that except as needed to receive pain medication, you know, if you're, like I had a friend who died not too long ago of pancreatic cancer. He was receiving a morphine drip when he died. And so you have to get some fluids to get pain meds. So they can't completely eliminate fluids in that instance. And then C would be if you wanted, even if you were not going to get better, you would want certain types of life support, but not others. For instance, so you could select C and then pick and choose what types of life support you would want between feeding tube, fluids by tube, ventilator, or CPR. The only one I've really had somebody use on that one is fluids by tube. They just said they, you know, did not want to dehydrate. So even if they weren't getting better, they wanted to be on fluids. And if we have any doctors here that want to, you know, add any insight to any of this, I'd be happy to hear that. Number 8 there, then additional statements. You could, I think if you read it, and you probably don't want to read it all right now, but for example, you might want to state your treatment preferences regarding medications to fight infections, surgery, amputation, blood transfusion, dialysis. You know, I mean, some religions don't believe in blood transfusion, so they want to put in there, I'm not going to get a blood transfusion. in case of pregnancy, at the bottom of that page, probably doesn't relate to anybody here, but in Georgia, if you're pregnant, and your fetus is, if you're pregnant, if you don't do anything about this in case of pregnancy, they're gonna keep you alive, regardless of what you said about life support. You can select down here, I want part 2, which is the part you just said that maybe you didn't want life support to be carried out if my fetus is not viable. If your fetus is viable in Georgia, by law, they're gonna keep you alive, but unless you've selected this one at the bottom, then they're gonna still keep you alive, even if your fetus is not viable. And I don't know what viable means. I've asked, never been told. Part 3 on the next page is important. It allows you to say who would be your guardian if you become incapacitated and a court decides that a guardian needs to be appointed for you. So you could select A, which is my agent, the person I've named several pages back is my agent, or B, you could select someone else and insert their name. Sometimes with this document and the next document in place, well, with this document, you shouldn't need a guardian because your agent should be able to make all sorts of decisions for you. But it's not foolproof. This doesn't take away your authority to make decisions. It just names someone else too if you can't. So most often I see this come up in terms of somebody with like Alzheimer's. They don't know that they don't have capacity any longer. And so their family's trying to get them in a facility, maybe a nursing home, a memory care unit, and they are adamant they're going to check themselves out. And the memory care unit says, we can't keep them. So then you have to go through the probate court to have someone appointed. Basically, they are declared incompetent, their rights removed, and someone has made their guardian. And so this is a way of telling the court in advance, if I get, when you're in your sound mind, if that happens to me, I want the person I've named as my agent to be my guardian. At the bottom is effectiveness and signatures. That's, you just have to sign it. It has to be signed in the presence of 2 witnesses. And you can insert it. Generally, it's effective immediately and then terminates either at your death or until you revoke it prior to your death. But you could insert a different effective and termination date if, for example, you just wanted it to, you're going into the hospital and you want somebody to have this authority for a couple of weeks while you're in the hospital. So again, then what would happen is you would sign this. If I prepare these for people, like they come to my office, we sign all the documents together, the wills, the healthcare directives, and power of attorney. They sign, and there are 2 witnesses. There are a few parameters on it. You read there, a witness cannot be your agent. It cannot be somebody who will inherit from you or benefit from your death. And it cannot be a doctor who's involved or a person who's directly involved in your health care.
Are you as a preparer allowed to be a witness?
Yes, I'm almost always a witness. Yeah. So
That would mean one of your children could not be
a witness. They could be your agent, but they could not witness your signature here. Unless you were leaving them out of your will, and then they might not want to be a witness. Yeah. So are there any questions about that document before I go on?
Let me just say, real quick from the church perspective, because this has happened a few times here, especially those of you who are single. It's really important for us to know who you have put on this document. If you, again, we can't change it, we can't do anything, but we can, but it's just helpful to know who that person is so that we can, if we make a pastoral visit, if you're in the emergency room and your designated person is not even in the state, then we will, we can know that and we can help share that with nurses and we can, give them the right information. But that has happened numerous times here. And we kind of get a little bit caught when we don't know who your person is. So just remember that when you're doing this document, but also when you're doing the document that we did last week, to just, let us know and put their information on that sheet as well.
And let me talk just a little bit about the importance of having this. If you don't have one, what happens? If you are in the hospital And nobody can authorize treatment, nobody can do these things for you. So there's some emergency situation, maybe it is a life support situation, you don't have a document in place and your family can't make those decisions because legally, nobody has that authority. So the family has to go through the probate court process of becoming your guardian. And that can be a drawn out process, and there's always a hearing, and it's a process. And it takes a while, and it's not a decision that can be made quickly, so if there's an emergency issue, nobody can address it. Also, let's say you have 3 or 4 children and they all disagree. One thinks you need to be in a nursing home, one thinks, oh, they're fine. You haven't designated anybody to make these decisions, so nobody has the authority. Again, you can go through the probate court to get that authority, but if you've got people who disagree, they're gonna be arguing about it, fighting about it. So, it's important to say in advance who's gonna make those decisions for you, and it saves everybody a lot of headache. And I think that's sort of my point here today is that documents that make it easier for your loved ones as you age. That's why sometimes this is more important than a will, because the will you can get by as long as you have a fairly functional family, but this is really important because doctors are not going to let somebody make a decision without legal authority. They can't. They're just not going to expose themselves to that liability. So
What's the difference in somebody just doing this form versus going to an attorney?
nothing. That's why, these are statutory forms. If y'all filled these out, you might not have the explanation. When I meet with people, I go through and, explain it just like I've done to you, but these are statutory forms. So as long as it's properly signed and witnessed, you're good. So, that's part of why I gave it to you today. If you want to fill it out on your end, that's fine. Yeah.
If you agree to be someone's guardian, are you financially liable?
No, you're not. This doesn't, if you'll notice, the agent doesn't even sign off on this document. So say you've named me and I could not even know it, and somebody comes to me, I'm not obligated to act. So you want to make sure that it's somebody who's willing to do it. But no, I don't assume any liability for that.
I'll share something with you. I volunteer at the hospital, and many times I've been called to witness this. So if you find that you haven't done one of these, it is available for you, because the nurses and the doctors can't sign, but a volunteer, they'll bring somebody in like myself to be a witness.
Right. So it's as long as you have capacity, that's correct. But if we don't know, you may have a stroke or something and you can't sign the document, you can't do it. Holly?
I think I have 2 of these out there since I was 50 years old.
Yeah.
So
The second
revoke
one,
one.
yes,
What do you do?
well, basically, when you do a new one, it revokes the old one.
The date would supersede.
But you can also just tear it up, write revoked all over it, any act
But
that,
if it's in like a doctor's office, then you would just tell them.
yes, tell them I've got a new one.
And also to Linda's point about, conflict about, funeral services, this document trumps the document that we did last week. This is a legal document, that one's just a planning form, so, just to make that clear as well. That's why this is really,
It really is important. You can get around having a will through other mechanisms, which I'll talk about if we have time, but you really can't get around this. Now, the other document I gave out is a statutory power of attorney. This authorizes somebody to handle your finances, your business matters for you if you become incapacitated. This is also, like I said, a statutory form. It's hard to use other forms. Most medical providers will take kind of any old form of a advanced directive, but after this statutory form came about in 2019, and most of the larger banks, brokerages won't take anything other than that now. So you kind of have to use this form. So the first page is just explanation. The second page is where you would designate your agent. And again, you can have backup agents, co-agents. Then at the bottom is a grant of general authority, and you can specify what types of transactions your agent could handle for you. Most people would initial all proceeding subjects at the bottom of that page so that your agent can handle any of these types of transactions. So, and sometimes I'll have somebody say, well, you know what, my kids are on all my accounts, so I don't need this. But can they call your cable company for you? No. Can they call your insurance company? You know how hard it is to call the cable company if it's like your spouse's name and you can't even report that it's out. You're like, it's just, why would I report someone's cable being out? Like, I don't know. So, yes.
So like if you have this form,
Mhm.
can the brokerage company tell you, no, you have to sign ours instead?
Some brokerage companies do have their own form that they want, but if you, let's say I have this form and I've designated Lizanne as my agent and then I have a stroke, they have to take this form, but if I'm capable, they're gonna want me to sign some other document saying, yes, I have this form and yes, Lizanne's my agent. So most people would initial all proceeding subjects on that.
Okay, then I have a question.
Mhm.
If you, so, if you filled out a power of attorney form 2 years ago
Mhm.
and you signed, and then like someone is incapacitated now and they haven't filled out any more,
Mhm. Mhm.
they haven't filled out this form specifically.
Mhm. Yeah, I mean, it's really up to like the provider of the service, so up to the bank, and so if some smaller banks, which are harder to come by these days, like United Community Bank in town, you could probably go there and it would be fine. But if you go to Wells Fargo or Bank of America, they're gonna say, no, we want that statutory one. So then you end up having to go through the probate court. So it is important to kind of stay on top of it, depending on, where your accounts are.
Okay.
And also it would let you like sell real estate, the things are real property, so that would be, you could sell your parents' house if you're their agent and they, they're going into a home and you need to sell their house, and tangible personal property, that'd be like your car, your jewelry, stocks, bonds, commodities. I mean, I think most of those are self-explanatory, but, and then on the second page, I guess it's the third page actually, grant of specific authority. So your agent does not have the authority to do any of these specific items unless you initial by them. And they're pretty broad. So, it's giving a lot of authority to somebody. It's like changing your beneficiary designation, making gifts.
Password?
All sorts of things. So, people say, well, what should I initial? Almost always they say, well, which one should I initial? It's up to you, and it's up to who your agent. I mean, maybe if your agent is just your spouse, you're fine with all of them. You'll be happy for your spouse to do any of these things. Sometimes people are concerned that if they've got one child named as an agent, that they might change their beneficiary designations around to, away from one sibling to another. So, you are giving a lot of authority by initialing these which is on the one hand good, because if something unforeseen comes up, it's easier for them to address. Maybe they find out, maybe you've got, 2 children named as beneficiaries of your life insurance and one of them's in a horrible accident and really just does not, like, it would be detrimental for that money to go to them at that point for some reason, becomes incapacitated and they're getting government benefits. And so this would kick them off their benefits. So the more you initial here, the more your agent can just address things that need to be addressed. On the other hand, it does give more wiggle room for, I guess, bad behavior. I did say that this document lets somebody handle your assets if you're incapacitated, and that is correct. But as written, it actually lets them handle them even if you're capacitated. So, I mean, I don't know if you've ever had like somebody, maybe a spouse, go to a closing out of town for you and there was a limited power of attorney, something like that. So this does not take away your authority to do anything, but it also would let your agent sign checks for you, for example. If you wanted to limit that authority such that they could only use this document if you're incapacitated, then we'd have to add some language in here under the special instructions. Also, if you read the fine print on the first page, it says if you've got co-agents, either one can act. If you wanted them to have to act together, let's say you've got your 2 children named and you don't want one to be able to act without the other, you'd have to put that in the special instructions if they're required to act together. So again, what if you don't have this document and you don't have, your kids on any of your bank accounts, everything's in your name or you're in your wife's name and you both are incapacitated? Nobody can access those assets for you or handle them. So what do they have to do? They have to go through the probate court. in this case, it's your conservator. The healthcare was guardian, this is conservator. They would become your legal conservator. It is a pain in the neck. They have to report to the court every year to the penny, what money came in, what money went out. If they had to sell an asset, they have to go to the probate court, petition for permission to sell the asset. If they need to spend more than your income, say for your care, they have to go to the probate court, ask for permission to spend, tap into your brokerage account to pay for your nursing home or something. So, that's why it's so important to have this document. And it does give somebody a lot of authority. So you want to, carefully consider it before you do it, but it's very important, to have that. Y'all have questions about that?
At what date did this become statutory?
It was 2019.
That's pretty recent.
Mhm. I don't like this form, honestly, and I've never talked to another attorney who does, but it can be confusing to read through. I mean, when I would try to explain it to people, especially maybe an elderly person, they don't, it's really hard for them to understand all
So
the.
if we think that we have done this
Mhm.
before 2019,
Mhm.
have we really?
Well, I would say I would do it, I would probably do another one. If you're concerned about it, could take your old one to your bank, your brokerage, and say, I've got this, are you all gonna accept this, or do I need to do something else, And I will say that too, once you do one of these, I encourage clients to take it to their bank, to the brokerage company, so it's on record, because if you go in and take it to them, well, they know that it's valid, you've given it to them, you've told them. Versus if you have a stroke and your child goes in, with this document, they're like, well, how do I know if he really did this, if he hasn't revoked it since then? So they don't want to get in the mess in the middle of a bunch of family squabble. So if you take it to them, it's on record, they know you did it. So if you have an older one, I would, just send it in to your, whoever, wherever you have accounts, and make sure that they're gonna accept it, or, will use it.
If I take it to several banks or several people, do I need to sign when I get there, or can I sign it before I go, or do I need a separate one for each?
No, you would sign it before you go. This document has to have a witness and a notary. It requires a notary. In addition, the healthcare director just needs 2 witnesses. But yeah, you would have to take it in, signed. You might get the bank to witness and notarize it for you, but you just have one. So typically you would take the original to them, and they would then photocopy it. Most banks or most companies are now going to say, well, we have to send it to our legal department to review. So, and then they'll send it to the legal department, and then they'll tell you yes or no. You can also, on bank accounts, add somebody, you can add a co-owner, and but maybe you don't want your child or someone as your co-owner. You can add them as just having signature authority, which means they can sign checks for you, but they can't do anything other than that. They don't get ownership. So if that is, helpful, or you can add them with the power of attorney. I had a power of attorney for an aunt of mine who died a few years ago, but I helped take care of her. And so I signed her checks, as power of attorney, and the bank had a copy of that power of attorney. So I wasn't on the account. I couldn't, access the funds other than to write her checks. Do y'all have questions? Anything else?
Does co-owner of larger accounts have tax consequences?
Yes, there are, yes. A co-owner, like a child, or are you talking about if you put a child on?
Or an in-law or son-in-law?
There are some consequences. One, that's considered half theirs. And depending on how the account's written, it could pass completely to them at your death. And while they may share it with other people, they wouldn't be obligated. The tax implications are more, really half the account, if there's any interest or dividends, technically half would be
It's
theirs.
income to them.
Yeah. Now, it's probably just being reported, say, to your social security number, so it's never gonna, as long as you're getting the income, it's probably not an issue, but. do you all want me to talk about wills? Do we have time for that, or do you?
Yeah, you got about 5 or 10 minutes.
That's
Okay.
all we need to know.
Yeah. So wills, I mean, that wills are important. Wills set forth where you want your property to go, where who's gonna be the executor of the estate. The reason I said earlier, you can kind of get by without a will is if you have, say, all your accounts set up payable on death or with a beneficiary, IRAs with the beneficiary designation, assets jointly owned. You can get by without a will. If you die without a will and there are assets that aren't jointly owned or passing through beneficiary, then in Georgia, the law provides that they pass to your spouse and children in equal shares, with the spouse getting at least a third. And then if you had a deceased child, that deceased child's children would get their share. So it can get a little messy if you have anything other than sort of a cookie cutter situation. If you've got a child who's difficult or a child who's disabled maybe and receiving government benefits and if they inherit from you outright, it's going to kick them off their benefits, then you would want a special type of trust for them, for example, or you've got minor grandchildren and, or a minor child, some minor that's going to inherit. They can't legally consent to anything. So it's going to create problems. So a will is important, especially if you don't have just the most vanilla situation, but, so. I don't know how much you want me to, I could go on for like hours about wills, but.
Do any of y'all on Zoom have any questions for Linda? No?
I don't.
Any other questions or?
Inter vivos trust, that's one set up while you're living. So that's what I know you saw that on the power of attorney. That's a trust set up during lifetime. So they could set up a trust for you during your lifetime, or amend a trust that you've already set up during your lifetime, if you have done one. That can come into play. There are certain types of trusts for Medicaid eligibility. If your assets are low enough that you would qualify for Medicaid, but your income is too high, but not so high that it covers the cost of a nursing home, there's a special type of qualified income trust that can be set up at that time. But somebody has to have the authority to do it, and nobody could unless you did that. So that can come into play. I mean, it's not that common.
Cool. Thank you,
You're
thank you,
welcome,
thank
you're
you. Let's give her a big round of applause.
Get those forms home with you, read over them, and if you have questions, I've got some cards if y'all wanna if you wanna email me, if you have a question that you think of later or anything.
I'd like one.
Yeah, I'd like to start.
And don't forget next week, Keith Hancock from Allman is gonna come and talk to us about the actual funeral preparation of, your remains, all of those other kinds of things. Keith will be here next week to talk about that. So thank y'all.
Okay.
And thank y'all on Zoom.
Hey, thank you.
Bye-bye.